New Mexico's Supreme Court has made a ruling that state oil and gas regulators say will severely crimp their ability to make sure drillers follow state rules. The ruling says that the Oil and Gas Conservation Division does not have the power, after all, to impose penalties on drillers directly. Mark Fessmeyer is head of the state's Oil and Gas Conservation Division. That's the arm of government that thought it had that power to impose penalties. I asked him what he thought the ruling meant.
Well, it significantly increases the costs and the resources that will have to be devoted to bringing compliance actions against operators who violate the Oil and Gas Act.
Give us a background. What was the case about?
What it was basically was an appeal of our rulemaking on enforcement and compliance rules. And what it does is it strikes one line out of the three-page rule, but it's an important line. The Supreme Court, in overruling the Court of Appeals and the District Court, said that the Oil Conservation Division doesn't have the authority to directly impose penalties for violations of the Oil and Gas Act. If we're going to punish an operator for violating the Oil and Gas Act, we have to revert to other portions of the law, or we have to bring a case in the District Court in the district in which the violation occurred. It doesn't mean that we don't have the ability to bring fiscal sanctions against an operator. We can still go through court, or we always have the ability under the law to, if an operator is in violation of the Oil and Gas Act, we can pull their bond, order them to plug any or all of their wells. It's a little bit of a drastic sanction for minor violations, but we always have that ability. So it doesn't leave us with nothing. It just leaves us with an atomic bomb for minor violations.
Well, let me see if I understand this correctly then. If you found someone, say, dumping or doing something like that at a well site, you couldn't fine them directly. You then have to go to court?
Right.
That's but even though you have the authority to regulate that activity.
Yes. Remember that this law was passed in 1935, and the provisions that we were trying to change are based on the original Oil and Gas Act in 1935. A lot of things have changed since then, but things that haven't are, for instance, the penalties that we can bring against an operator. If we do take them to court, and if we go to the expense of taking this through the court system and we prevail, we then have to start another action in that same court to collect the penalty. You know, we have to go through the court to implement it, then we have to go through the court to collect it, and if we do, we can collect a penalty of up to $1,000 or $1,000 per day for an ongoing violation. This was part of the original 1935 Act. We don't believe that the Act intended for us to do that, but the Supreme Court does, and now it's the law. The Supreme Court sets the law. Our interpretation does, or the interpretation of the lower courts doesn't matter now. The Supreme Court has said we have to do it this way.
Now, in the meantime, while this is in court, the operator can continue doing whatever they're doing.
Yes. That's the way we have to address the problem.
You'll need a lot more lawyers, and all of this takes a lot more time.
Exactly. A lot more time, a lot more expense. This basically makes it more difficult to enforce the laws that are in place.
And there's nowhere you can go. The Supreme Court has ruled.
Right. We can go to the legislature. We've been trying since 2005 to go to the legislature and tell them we need to change these 1935 provisions. But the oil and gas lobby is probably the most powerful in the state, and we have not been able to. We tried in 2005 and we tried in 2009 to get these laws changed, and they didn't get past the first committee. For instance, in the Senate Conservation Committee, we had probably a dozen people stand up and speak in favor of Senate Bill 361, and we had one person speak against it, and that was the president of the Oil and Gas Association, and the committee tabled it unanimously.
What did the Supreme Court use as their reasoning for the decision?
Their reading of the law, it was ambiguous. We thought we had a correct reading. Marbob thought they had a correct reading. The lower courts agreed with us. The court that matters, the Supreme Court, agreed with Marbob.
So if you change the law, then it might clear things up.
Right. But we, given the makeup of the legislature and the committees that we have to go through and the absolute strength of the oil and gas lobby, we are very, very
You're not optimistic.
Pessimistic, yeah.
Mark Fessmeyer, thanks so much.
You bet, sir.